Hi, everyone. I'm Jamie Talt. I'm a senior associate at Farella's employment practice group, and I am going to be presenting on best practices for managing medical and recreational cannabis in the workplace. I'm going to start off with some general background information just to make sure we're all on the same page. So, products containing two primary cannabis derivatives are available to consumers. The first is THC. This is a psychoactive derivative that often causes impairment. The other is CBD, which is the non-psychoactive derivative. Typically, it does not cause impairment. You often see CBD, in the aisles of the grocery store, kind of infused in ointments and whatnot. There's also hemp, which is a cannabis plant containing CBD and no more than 0.3% of THC. Okay, so the federal lay of the land. For now, non-hemp cannabis is a Schedule I controlled drug. That means it's illegal to possess, use, or sell cannabis. Note that in August of last year, the US Department of Health and Human Services announced that it would recommend moving marijuana to Schedule III. But for now, it's a Schedule I drug, which means that it has no currently accepted medical use and a high potential for abuse. In terms of hemp, the 2018 Farm Bill removed hemp from all schedules. So, focusing now on California. In 2022, California passed AB 1288, which has gone into effect as of January 1st of this year. So, what's changed? As of this year, California's Fair Employment and Housing Act, also known as FEHA, now prohibits discrimination based off of one, the use of cannabis off the job and away from the workplace. It also prohibits discrimination based off of an employer required drug screening test that has found the person to have non-psychoactive cannabis metabolites in their hair, their blood, urine, other bodily functions. So essentially with this bill, California now protects the off-duty use of cannabis. The law does not apply to employees in the building and construction trades or applicants or employees hired for positions that require a federal background investigation or security clearance. So the new law still permits employers to maintain a drug and alcohol-free workplace. But if employers are drug testing employees, they now need to use these new and improved drug tests that determine if an individual is currently impaired, instead of testing using drug tests that really only show the non-psychoactive metabolites. For example, drug tests that would show, someone has used cannabis in the last few days, few weeks, what have you, at which point, they wouldn't be impaired anymore. So let's talk about drug testing for a little bit. So as background, drug tests capture THC, which can stay in the body for up to 90 days. And that kind of varies with one's use. So for example, if you are using maybe a more potent strain, that is going to stay in your system potentially longer than a less potent strain. Similarly, if you are a less frequent user, you're probably going to get it out of your system sooner than a frequent user. And different testing methods have different sensitivities. So on the PowerPoint, you will see kind of general guidelines. So overall, the blood tests pick up THC closest to the time of use. And then that's followed by saliva, by urine, and by hair tests. There doesn't really seem to be much consensus on the exact time span that each type of test captures. So for example, some saliva tests will say that it'll capture THC from anywhere like 4 to 24 hours after use. Other tests say, it can go up to 72 hours.
And just to chime in on that, Jamie, I think what we take away from that as an employer is, the problem with these longer lifespans on these tests is if you test an employee and you've got this big window, they could very much claim that the use was from prior to when they came to work. So that's why we're really, when we look at this list, we're thinking, blood test at noon, the employee is going to have a hard time arguing this was off-duty use.
Right.
Yeah.
So we'll go over some common times to test. The first is pre-employment. This is done only after a conditional offer of employment has been made. Advance written notice is usually required. Second, pre-assignment tests. This is generally requested by a customer before site work. This is illegal in California unless there is a compelling safety reason to test. What we most often see during employment is reasonable suspicion testing. So that's generally accepted, but it has to be based off of objective facts relating to a particular individual that would suggest to a reasonable person that the individual is under the influence in violation of company policy. The next is random drug testing. This is banned in California, except for employees in public jobs where public safety is a concern. And finally, there's post-accident drug tests. These are for non-trivial serious accidents only and are best for safety-sensitive positions. So with that background, just some best practices for cannabis testing. We definitely recommend having a clear written policy in place prior to drug testing. And that policy should define who is covered. It should explain the circumstances where you might implement the different tests. It should describe the procedures for those tests. And it should spell out disciplinary consequences for refusing to test or testing positive. And it's obviously very important to be consistent in enforcing that policy. So kind of focusing on procedures for a little bit, generally urine testing has been pretty common, but as Holly kind of alluded to, urine tests can show metabolites from, days after use, which could run afoul of this new law, which again is really focused on making sure drug tests show current impairment. So there seems to be a trend towards saliva testing, which is a little less invasive than blood tests, which I think are the most sensitive. So it's probably worth confirming with a drug test vendor, if you use a drug test vendor, that they're aware of this new law, are they using saliva tests? What are they using to stay compliant? And then also focusing a little bit now on reasonable suspicion. So again, reasonable suspicion tests must be based off of objective facts that indicate impairment. Again, given that these drug tests are evolving, it's not completely clear, exactly when they capture the metabolites. It's going to be really important to document the objective facts that indicate current impairment. So that's things like, did the employee have bloodshot eyes? Were they slurring their words? Were they maybe not walking straight? Were they having difficulty comprehending questions being asked? Were they losing their train of thought? Those kind of objective facts. And, another one might be smell, but there is an argument to be made in terms of at least cannabis that it can linger on your clothing. So I think probably smell alone is not going to be quite enough, because someone could easily say, like, hey, my sweater was in my closet from days ago. It has nothing to do with my current condition at work. So it's going to be really important to also train whoever is handling these reasonable suspicion cases to make sure they know what to look out for. So these objective markers and the need to document those objective markers.
I think I would add, and Jamie, you can tell me if you agree, it's, I think it's a good practice also if if one of your managers contacts you and says, so-and-so is really out of it. I think she's impaired. And so then you go through this routine of documenting the observations to have a second person. So pull in either, a second manager or someone from HR so that it's not just the one manager who was the witness here. It's good to have a second person who can independently confirm these observations.
Yeah, I think that's a great point. Yeah. So, question if, do employers need to permit recreational cannabis at work? So as I mentioned earlier, California's new law still permit employers to maintain a drug and alcohol-free workplace. So no, employers do not have to allow employees to work while impaired. It's often ideal, in most sectors, to have a zero tolerance policy. And if you do have a zero tolerance position, that should be reflected in a policy. So do employers need to allow employees to possess legal recreational use cannabis at work, for example, in a desk or a locker, even if they're not using it? And for this one, the answer is it depends. If employers want to prohibit having employees possess drugs at work, then they should include that in a policy, and that is totally okay to do.
So I think there again, you want to make sure you're clear because you might say illegal drugs, and it's a question well, it's legal in California. So when we're working on handbooks, we try to we add an extra sentence, including cannabis, or excluding cannabis, depending on what your policy is.
Now turning to CBD, and again, CBD is the non-psychoactive derivative. So what can employers do about CBD at work? This is a bit more of a gray area. So as far as we know, current law allows employers to treat CBD the same as recreational cannabis or differently at their discretion. But whatever they choose to have their policy be, it needs to be applied consistently. Similarly, with reasonable accommodation, generally the same rule of thumb, employers can treat prescribed CBD in the same way that they choose to treat medical marijuana. So turning now to accommodation and medical cannabis. As I'm sure you all know, employers generally must make reasonable accommodations that allow employees to perform the essential functions of their job. But no state actually requires accommodation of medical cannabis use or possession on the job or in the workplace. And California law actually explicitly states that on-the-job use is not a reasonable accommodation. So at least as of right now, reasonable accommodation does not require an employer to allow employee to work while impaired or keep cannabis at work. So some key takeaways overall. With California's new law in effect as of January 1st of this year, it is illegal for most employers to discriminate against employees on the basis of off-duty cannabis use, but employers can still prohibit working while impaired.
So just to say a little more on that, because those things seem kind of inconsistent, but if you know that an employee is a cannabis user, the new law says you cannot discriminate against them. They talk about using cannabis at work. They're open about their use. As long as it's off-duty use, you cannot discriminate against them, i.e. you can't fire them, you can't decline to promote them. It is a new protected class in California, which is, getting some interesting commentary nationwide, right? But it's right in there with race and age in terms of being a protected class. So just something to be aware of. At the same time, as Jamie says, that does not mean that you have to allow anyone to use it at work or come to work impaired. It's a little bit of a, line to walk there between those two.
Yep. And to make sure you're in compliance with this law, employers should update drug policies to make clear that off-duty use of marijuana will not be penalized, again, unless they're impaired at work. And then also, like we talked about, updating reasonable suspicion policies and definitely the training for people implementing those policies to emphasize the importance of observing and documenting those symptoms of impairment, like the bloodshot eyes and whatnot. And then, as we've talked about, California does not require reasonable accommodation of cannabis, and you can treat CBD the same as cannabis. So that's all I have. If there's any questions from the group as well as on Zoom, I'm happy to take it now or later. Okay.
Just a point of clarification.
Yeah.
Non-psycho
Active derivatives.
Cannabis metabolites.
Uh-huh.
So those can come from THC use, but it's like after it's no longer active in your system in terms of.
Right. Yeah. So it seems that you can use products containing THC, and as it breaks down over time, it would become this non-psychoactive element that could still show up on a drug test. Yeah.
In order, in terms of the objective facts to document, that smell by itself is likely not going to be sufficient to support that somebody has recently been using cannabis. But is smell on its own sufficient to raise reasonable suspicion?
So I would say that could be risky, same as using or noting just smell when you're documenting it. I think without the sort of other markers, you would open yourself up to some risk because, like I said, smell could be just something lingering from prior days or earlier and doesn't really show, that they're actively impaired on the job.
I mean, it occurs to me if somebody was wearing a big coat and they said, oh, it's just my coat, I'd be like, well, take your coat off and then come over here. Let's see. But we would definitely suggest that you try to identify the other signs of impairment, and often that's just confusion. Sometimes people are falling asleep. Usually smell would just be one of several factors that we're looking at. Yeah.
Okay. Thanks, Mom.
Hi, everyone. My name is Ben Buchwalter. I'm special counsel here at Farella. I'm really excited to talk to you all today. We're going to start out with a really exciting one, which is about California's new requirement that most employers implement a workplace violence prevention policy. You may have seen this in the news. So the goal for today is we're going to talk through what this means for employers, what needs to be included, and then I think probably most importantly, some practical tips for how you can go about doing this. So on this first slide, we have some kind of key takeaways from the new law. up here at the top, just, brass tacks, the law requires most employers to create a written violence prevention policy. That includes implementing some sorts of training and also recording incidents of workplace violence. Now, as you can see here on the slide, workplace violence is defined incredibly broadly. And we're going to talk through a little bit more about some delineations in that definition that the law created to help with record keeping purposes, to help identify, oh, this is a kind of specific type of workplace violence that actually happened. Now, what types of employers are covered? The fact is, most employers in California are likely covered. There are a few limited exceptions to the law that I've put here on the slide. I want to focus a bit on two of these exceptions. The first one is that second bullet point there. If you're a company that doesn't actually have a brick and mortar presence and all of your employees work from home, this law doesn't apply to you. It would, that's sort of logical. It wouldn't make much sense for you to have a workplace violence prevention policy if no one's actually on your premises. The next one I wanted to emphasize is the bullet point right under that. If you're a location that is not open to the public and you have less than 10 employees, then the law does not apply to you. Now, that's sort of helpful, but it's also not helpful because we don't know what locations not open to the public means. It just doesn't say it in the statute. I think it's likely, though, that if you're a workplace where generally you don't have people just walking in and out from the street, but you do allow guests to come, maybe they sign in at the front, they get a special badge, and they come back and meet with you, then you would likely be determined to be a workplace that's open to the public. But this is a new law. Some of this is still changing, so some of that might switch. Now, the compliance deadline is July 1st, 2024. So when I saw that, my first response was, great, employers have a little bit of time to do this. Now, we all know that in your day-to-day work, you're dealing with all sorts of issues, tricky employment things, you're writing other policies. So, those months are going to fly by. So I'm glad we're talking about it today so that you can hopefully get ahead of this and start working on how you're going to be in compliance. Now, speaking of compliance, this law does specify that there are some penalties for non-compliance. They're not very specific about what they are, but they would be imposed by OSHA. Those would be civil penalties. They would be appealable, and there's a delineated process within OSHA for how that appeals process happens. One saving grace in the law that I was really happy to see is that it says there right in the language that companies who make a good faith attempt at compliance with this law will not be assessed a penalty for a first time violation. So long as they, express that they are going to fix whatever the problem was. So, we're going to talk about training in a little bit. If, for example, the OSHA looked at your training materials and decided that they weren't up to snuff, the first time that happened, they would identify the problem to you, and you would have an opportunity to fix it before they assessed penalties. I'm not sure if that part of the law is going to be present in 5 years or 10 years. It's something that maybe will sunset out, but for now, that's the state of it. Now, let's dive in a little bit more into the definition of workplace violence. The definition, I'm just going to say it aloud, is any act of violence or threat of violence that occurs in a place of employment. Like I said, that's quite broad. It includes any threat or use of physical force against employees that causes or has a high likelihood of causing injury or even psychological trauma or stress. And then certainly any incident involving use of a firearm or other dangerous weapon would be included in that definition. Also included on this slide are 4 different types of workplace violence that are identified for the law. Now, at this stage, I don't think it's important to memorize exactly what these types are. What they're there for is that, there's a record-keeping requirement that we're going to be talking about in just a minute. And part of those record-keeping requirements is that you need to identify what type of workplace environment happened on your premises and they fall into these 4 categories. Now, finally, the law goes out of its way to say that self-defense is not a form of workplace violence that you need to track. Although I would say that I think you can take that one with a bit of a grain of salt, because if there's self-defense happening, then there's probably some sort of workplace violence that's happening that you need to record. So, you can note in the notes that there was an incident of self-defense in there, but it's probably something you're going to have to be recording as well.
And I was reading this, Ben, and I was thinking about it, how your mention of how broad things are, because I actually had a recent call with a client where an employee was overheard very angry at his PC, at his computer, and threatening to get a gun and shoot the computer, right? And that would fall within your definition, even though there was nobody actually threatened. And I think it's actually helpful to take a broader approach too, because the goal ultimately is hopefully to find people who are experiencing high degrees of stress and try to make sure they're getting some help, right? Get the EAP and sort of have somebody keeping an eye on that person. So that's why I think even though it's a little bit more burdensome in the record keeping, I think the overall impact is going to be positive.
That's a great point. And you flagged something for me that I wanted to mention, which is that, this law is backward looking. It's assuming that there's been an incident of workplace violence that you need to record. In some ways it's backward looking, but there's the element of the policy that is forward looking as well. And as part of that, there's something that I'm sure all of you are already doing, which is monitoring your workforce and seeing if there are instances that could potentially lead to violence and trying to address those before it actually comes up. I think that's a really key aspect of this. So what needs to be included in the plan? Before I list that out, I wanted to note that this is something, the statute says it needs to be in writing and it needs to be easily accessible. Now, if you have in-person workplace, you can go ahead and have a printed copy that is available. But I'm sure that none of our workforces actually work that way. And the best way to do it is probably to have something available online on your intranet system. When you roll it out, even better if you email it out to everyone so they have it handy and available. One key point here is that, this is ideally something that can be used in when there's an incident that is extremely dangerous and an extremely high stress moment. So people aren't, it's not going to be easy for people to go through the office and try to find a printed out version of this policy if there's a workplace violence incident. So having something that's available for them online, I think is really important, although it's not specifically required by the law. Some of you may have an injury and illness prevention plan already. If you do, that's great. If you don't, this is something that, this may be a reason to begin to implement one, because the law makes clear that, this workplace prevention policy, it can be a standalone document or it can be included in an already existing IIPP. So here's what needs to be included in the plan. This is at a minimum. And by that, I mean, your company, you have your own culture and you have, your own way of writing policies. There may be additional things that you include. What I've listed here is what the statute says needs to be in there. First, names of job titles of team members responsible for implementation. One way that I've seen this done is to identify the actual job title rather than a specific person, because I'm sure as you've seen in your business, there's some turnover. And if you put someone's name in there who eventually leaves and say you forget to update the policy, you're going to be in a situation where no one's going to know who they're supposed to contact. So I think that's a good way to go about it, is to identify the job title as the person who's responsible. Also, procedures to obtain active involvement of employees. One way to do that is to potentially have a meeting where you ask employees for their input of, what do you see as some of the potential types of workplace violence that could happen? What do you see as some of the detriments of having an effective policy here? And doing your best to implement those, what you get from those meetings. That's not to say you have to do everything that is suggested, but think about it, make an effort to include the really good ideas there. I'm going to skip a little bit to the bottom, and I want to note guidelines for periodic review of the program. The law does not say specifically how often you need to review it, but it's a good idea to get in the practice of doing it on an annual basis. You know, maybe it's the person who you identified as responsible for implementation, but they just put, you know, a calendar invite for July of 2025 to go ahead and look at this. And maybe they'll do that in conjunction with HR or employment legal. So then you're doing it on an annual cadence, and it's just part of the process, rather than waiting, I don't know, 4 or 5 years to let this thing get out of date. So as I mentioned, this law also has some training requirements. Now it says that employees need to be trained after implementation of the plan and then on an annual basis thereafter. Most employers I'm talking to are seeing this as probably the most frustrating part of the law, because I'm sure you all have employees who it feels like they're constantly being pulled out of their day-to-day work to be in different trainings. And people can get frustrated by that and feel like, you know, especially managers and executives can feel like we don't want to pull people away from what they're actually doing. So, you know, I've heard some people talk, you know, ask, well, what do we actually have to do here versus what are the best practices here? So, you know, I'm going to talk about what kind of the gold standard would be for training, and then I'm going to give some practical advice about, you know, ways you can maybe make that easier to do, or some, you know, risk-based choices you could potentially take. So here, you know, at a minimum, that training needs to include details of what the plan includes, definitions of workplace violence, how to report workplace violence without fear of retaliation, identification of potential workplace violence, an explanation of the violence incident log. We're going to talk about that on the next slide, and an opportunity for questions. So I think the gold standard of this would be something including all of that is a in-person training where you're writing down people's attendance and getting that on the books. Because as we're talking about on the next slide, attendance records is actually one of the required record-keeping requirements. Like I mentioned, I've heard some employers bristle at this a little bit. And so one way to potentially make it a little bit easier to do it is to, you know, make it kind of a fun thing. You know, I worked with one company that decided to have a whole safety day. And they had, you know, 3 different sessions where they had 3 different 30-minute sessions. So they made it easy for people to join when it fit their schedule. And then they had safety snacks there, and they had fun music when people walked in. And it ended up being a way to make this, you know, not something people groaned at, but something they actually kind of look forward to. That's one way to do it. Also, you know, as I noted before, the law says that a first violation wouldn't result in penalties. So companies could make risk-based decisions that they're going to take a different approach, maybe refer people to a deck that is a training that they can do on their own time. I don't think that would comply with the law as written, but you know, some employers are going to be making some risk-based decisions, and if that's something you're interested in, you know, we'd be happy to have that conversation with you about where to draw the line there. Record keeping. So I'm not going to go through each part of this, but the summary here is that some types of records need to be kept for 5 years, including the violence incident logs, and then some types need to be retained for just 1 year, such as the names and the dates of the trainings. I'm going to talk briefly about those violence incident logs because I promised you I would, and I don't want to break my promise. So those logs need to include the date, time, and location of the incident. Those workplace violence types that I went through before, those were type 1, type 2, type 3, type 4. And a detailed description of the incident and a description of who was involved. There are other factors there that are, there's actually quite a long list in the statute, and I'll spare you from going through all of it. But those are sort of the key points. And if you have questions about that, I'd be happy to talk to you afterwards. Now here we have some resources. happy to provide these links if you reach out. But one thing I wanted to note is that OSHA is going to put together a model plan. It's not out yet, so that's not very helpful at this point. Hopefully it'll be out before July 1st. But if it's not, another option is, we would obviously be happy to help you with that. And also, if you already have a third party that you work with, like ADP, it's pretty likely that they have a template policy that you could use at least as a starting point and maybe edit it to match your firm's culture and the way you like to write these things. But something to think about. And there is an model injury and illness prevention policy that is available right online there. So again, happy to provide these links. So before we move on to the next section, I want to pause and see if there are any questions.
Is there a private right of action aside from OSHA's or Cal OSHA's enforcement of this?
There's not. Yeah.
Does your log of incidents have to be its own log, or can it be incorporated and searched like with your other security incidents, for example?
It can be incorporated with the other security incidents.
So when you said that this has to be in writing and easily accessible, can this be put in your employee handbook, or should it be referenced in the employee handbook and then have it as a standalone?
I think it's better practice to have it referenced in the employee handbook and have it in its standalone document. And the reason that I say that is because, if you needed to update something in the workplace violence prevention program, but you didn't need to update the whole handbook, it would put you in a position where maybe since you're updating one part of the handbook, you would need to update the whole thing, and keeping it separate can make that a little bit easier. Any other questions? All right, we're going to move on to non-competes, another extremely fun topic. As you all know, California has long been skeptical of non-compete agreements. As I say skeptical, I think that's sort of a tepid word for what it actually is. I think it's outright hostility towards non-compete agreements. That's been, put in place by past laws, but also consistent case law knocking down non-compete agreements in California. This year, 2 new statutes took additional steps to strengthen the laws opposing non-compete agreements in California. So we're going to touch on those 2 laws. Starting with Senate Bill 699. The takeaway here is that any non-compete agreement in the state is deemed to be void regardless of where and when it was signed. Now, this law officially goes into effect January 1st of 2024. But what this means is that if there are any existing non-compete agreements in California, they would be void retroactively, regardless of when they were signed.
And Ben, I think just to clarify that what we're talking about are unlawful non-competes. Some of you may know there is a very, very narrow category of non-competes which are allowed in California. And that's really limited to when you are selling a business or a partnership or something, an LLC, and you're selling the goodwill. And when there's a sale like that going on, then you can agree, if you're the seller, that you will not compete now with the buyer because you've just sold them your business. And so those we're fairly confident, that's not changed. But we also see it's not uncommon to see non-competes in California still floating around that are illegal. And until this law was passed, it wasn't clear whether there was real liability for having an unenforceable non-compete out there in your documentation. And I've heard parties say, well, I'm going to put it out there and maybe people won't know it's not enforceable and they'll abide by it. Well, now, as Ben is explaining, there is clear liability for that practice. Yeah.
Thank you.
Yeah.
Yeah, and on the liability side there, there was a question before about a private right of action. Here, this law does actually create a private right of action for having an unenforceable non-compete in California. And the employees can seek injunctive relief to void the agreement, but also actual damages and attorney's fees and costs. So that can really add up. Moving to the other statute that was passed this year, this is Assembly Bill 1076. And this law makes clear that, again, California's prohibition on non-competes is to be construed broadly, and it's supposed to void all competes, all unlawful non-competes in the state. Now, one part of this law in particular that I think is going to be really challenging for a lot of employers is, if you do have an unlawful non-compete on the books, this law says that you need to reach out to everyone who has that non-compete agreement by February 14th, a little less than a month from now, to let them know that that agreement is void. That's something that, I don't think a lot of employers are going to enjoy doing, but it's what the statute says, and the statute also imposes pretty steep penalties for non-compliance with the law. That $2,500 per violation penalty here on the screen, that applies to both having an unlawful non-compete agreement, but also to not complying with that notice requirement that I just mentioned. So, if there's one unlawful non-compete out there, the company may make a risk-based decision that they're not going to reach out to the person. If you have 100 or 1,000 unlawful non-competes in the state, then that $2,500 can really add up. So, it's probably better to just have peace of mind and reach out to people and let them know that those agreements are void.
And this will apply to any employee, including former employees that have been with you since 2022. So if you have a company that, again, we see this a lot when they were using out-of-state employment agreements for California employees, and sometimes they'll have these buried in there. And even if you fixed it, but there's a few people out there, former employees from back in 22 or 23, they're also covered by this notice requirement.
Before we move on to the next section, are there any questions on the non-competes? All right. Oh, one question. Hey, Daniela.
A quick question. So just to clarify the notice requirement for any former employee since 2022, is that any employee who's been employed since 2022 or since the non-compete has been signed since 2022?
Any employee who was employed since 22. Yeah.
Thank you.
Yeah.
All right, so there was also a new law this year that created a rebuttable presumption of retaliation if an employee is disciplined or terminated within 90 days of a protected complaint. This is sort of an interesting one because on the one hand, this is a pretty big change. But on the other hand, in some ways, this is business as usual. We all know that if you take an adverse employment action against an employee in close proximity to a complaint they made, that's a risky situation. So in that way, the law doesn't change all that much, but it does change how courts are going to be approaching claims of retaliation. Now, for example, these types of claims, they follow the burden shifting analysis where people need to first make a prima facie case where then the employer can identify its legitimate reason for the termination. Now, this law sort of takes out that first step where it says we're going to already assume that the person has a prima facie case if they meet the other factors of a retaliation claim, if it is within 90 days of a protected action. And it basically means that the employer needs to effectively has the initial burden of saying that they made a legitimate decision, at which point the employee would have to show pretext. This does not apply to all types of retaliation claims. It applies to labor code retaliation claims, including whistleblower retaliation and unequal pay. But it's something that I think you're likely to see from employees who have retaliation claims in any context, regardless of whether it's accurate that it applies there. One question I think we see a lot is this retroactive? Right now, it's pretty unclear if it's retroactive. The law doesn't say, and there hasn't been any interpretive guidance clarifying that. But I think it's safe to assume that moving forward, judges are going to be applying this new standard. So what do we do now in face of this new law, creating this whole new presumption? Well, as I'm sure you're already doing, one key thing is to pay close attention to the timing of performance management in proximity to a complaint. And that would also apply to a performance improvement plan or other formal discipline within 90 days of a complaint. But note that this 90 days is not like a bright line test where, you know, if you clear that 90 days, then you're safe. If you took action against someone after 90 days, someone could still say that that was in retaliation for a protected complaint earlier. Yeah.
What if somebody just keeps complaining? Does it keep resetting the clock?
It does. And so, you know, that actually leads to this next bullet point here is that's why, as always, it's incredibly important for employers to document their, you know, the issues that they're having with employees. You know, I think a lot of managers have a tough time with this, like actually documenting their tough criticism for employees. So, you know, as you move forward, as much as you can document issues with employees, it'll help that you can establish that legitimate business case. Any questions on this rebuttable presumption? Yeah.
Does SB 497 have any implication when somebody raises concerns or like for an internal investigation related to harassment or discrimination?
Yeah, I think it would apply to complaints within the context of an investigation of harassment. Thank you all very much. I'm gonna hand it over to Ryan, who's gonna talk about some other exciting updates.
Great, thank you, Ben. My name is Ryan Wessels. I'm a senior associate in Farella's employment practice group. This is my 7th year working here and in employment law. I want to start off by talking about leaves. It seems like every year, California is either adding a new protected leave or modifying a protected leave. Sometimes those leaves are pretty obscure. I don't know the last time I've seen a civil air patrol leave or a bone marrow or organ donation leave. But sometimes this year and last year included, there are leaves that are generally more applicable to the entire workforce that come up more commonly, and particularly with the bereavement and reproductive loss leaves that require some sensitivity in how the employer may handle those leaves. So as a reminder, effective of January 1st of last year, employers are now required to provide up to 5 days of unpaid leave for bereavement leave for the death of a family member. The family members are your usual spouse, registered domestic partner, child, parent, including parent-in-law, grandchild, and grandparent. And importantly, employees are allowed to use any paid time off options they have. So while the leave is unpaid, if the employee has sick leave available or other paid time off options, they must be allowed to use that time. The bereavement leave law applies to any private employer with at least 5 or more employees, so almost every employer, and almost every employee as well. There's no exception for part-time or temporary employees. As long as the employee has been with the company for at least 30 days, they are entitled to the 5 days of bereavement leave. The bereavement leave has to be completed within 3 months. The law requires that employers allow the bereavement leave to be completed within 3 months of the date of death. Employers can obviously be more generous with that timeline. There's no annual bereavement leave cap. So if an employee has multiple deaths in the family, they're entitled to repeat these 5 days of bereavement leave. The employers are explicitly allowed to request documentation, and they have to keep that documentation confidential, but they can request the documentation to confirm a death in the family. Effective this year, we have the reproductive loss leave, which is the sister bill to 2023's bereavement leave, which largely tracks the bereavement leave bill, but with some notable exceptions, which I'll discuss. Reproductive loss leave applies to any time an employee loses a child in the event of a miscarriage, stillbirth, failed adoption, failed surrogacy, or unsuccessful assisted reproduction. estimates are that 10 to 20% of pregnancies end in miscarriage. Today, about 2% of all pregnancies are through assisted reproduction, and about at least 75% of those, depending on the age, may be unsuccessful. So relatively common situation and a very sensitive situation for employers to handle. Oftentimes with miscarriages, they're early on in the pregnancy in situations where the employer doesn't know that the employee is pregnant or family planning. And so the employer is getting some new information that they're going to have to tread carefully going forward once they have that information available. Importantly, this applies to both the birth parents, but also to anyone who would be the parent of the child had the reproductive event been successful. There are two important differences between this and the bereavement leave. First is there is a 20-day cap on the reproductive leave in a 12-month period. So a 5-day unpaid leave that can repeat 4 times in a 12-month period. And secondly is the statute is silent as to whether documentation, the employer can request documentation. And especially because bereavement leave explicitly allows documentation, the best practices would not be to ask for documentation in this situation. Again, extremely sensitive situation. And so we would advise against asking for documentation. We would also suggest training employees. Again, oftentimes this is news to the employer when an employee tells them, hey, I just had this reproductive loss. And so you want to make sure that your HR personnel or whomever is fielding this request is handling it with the appropriate sensitivity and is not making any comments, which we certainly would expect them not to, but expressing any sort of displeasure about the potential family planning. And both this and the bereavement leave statutes prohibit any adverse employment actions based off of requesting such leaves. And so, as Ben just mentioned, with the rebuttable presumption of retaliation, employers should be very careful as to taking any adverse action when an employee requests either bereavement leave or reproductive loss leave. Paid sick leave. So this one's another universally applicable leave. It applies to all employers. And because of that, it's a very important leave to get right. Like many issues, we often see issues with sick leave come up when an employee is terminated. They may seek counsel to see if they could challenge their termination. A good plaintiff's attorney won't stop at the termination, but will ask them for other documents related to their employment, ask them for their pay earning statements. And in the course of receiving those earning statements, because paid sick leave has to be mentioned on either the earning statement or on a document that's provided to the employee at the same time as the earning statement, they identify these sick leave issues. And these potential sick leave issues, it's an automatic liability for the employer, and it could be asserted on a class-wide basis when the employer gets this wrong. So again, it applies to employers of any size. There's not the same 5+ employee rule as with the last 2 leave. And it applies to virtually all employees. So some employers, what I've seen in my practice is with employee handbooks is that employers have a PTO policy, and it includes both sick leave and vacation leave. And they say this policy applies to all of our full-time employees. But then they say nothing else about their part-time employees and their temporary employees. And so it's important that you make sure to account for the sick leave requirement for your part-time and temporary employees as well. Sick leave can be used for the diagnosis, care, or treatment for themselves or a family member. And it's the same definition of family member that I discussed for bereavement leave. But as you may recall, that was just implemented recently. Sick leave has this designated person addition. So an employee is allowed to designate one person in a 12-month period in which they can take sick leave for. They don't need to designate in advance, and the person does not need to be in a familial relationship to them. Importantly, this sick leave regime is the California minimums, but other cities have their own sick leave ordinances. San Francisco, Berkeley, Emeryville, Oakland are the Bay Area cities that have such ordinances. And typically, and the employer should provide the more employee-friendly sick leave policy. There are some situations in which the state law will preempt the local ordinances, but generally you need to look at both the California state sick leave law as well as the local law in deciding what the policy should be. So what does SB 616 change? So first, it doesn't change anything as to the lump sum versus statutory accrual method. So employers can choose, do I want to front load the employee's sick leave with the lump sum method, or do I want them to accrue sick leave as they work throughout the year? That has not been changed. And under the accrual method, it's still 1 hour of sick pay for every 30 hours of work. That includes overtime hours for non-exempt employees. For exempt employees, that's 40 hours per week, unless the employee actually is scheduled to work less than a 40-hour work week. But employers can both cap the accrual and they can limit the amount of sick leave to be used in a year. And SB 616 modifies both of those caps. So now the accrual cap is 80 hours or 10 days, and the usage cap is 40 hours or 5 days. And importantly, if you have any employees who work an alternate work schedule, it's whichever is greater. So 40 hours or 5 days, whichever is more friendly to the employee. So for example, let's say an employee works a 4x10 shift, 5 days of sick leave would be 50 hours. So they would need to have 50 hours of sick leave instead of just the 40 hours. The lump sum approach, this is where the employer gives the employee the sick leave at the start of the year. It's not dependent on how many hours the employee works. Benefits to the lump sum approach is there's no carryover requirement. They get a blank slate every year, administratively easier to implement. And SB 616 increases that front load amount from 3 days or 24 hours to 5 days or 40 hours. Some employers have discretion as to when that year starts. It could start at January 1st. It could start at the employee's anniversary dates. If you do start at the employee's anniversary, if you start at any time other than January 1st, you're going to have to make some changes now to account for that method. So if you give your employees 24 days at the date of hire and every year thereafter, you're going to have to either change that to January 1st or give them the 2 additional days right now to use before their anniversary time. So takeaways, lump sum versus statutory accrual, which should you use? The lump sum approach, you end up having to give your employee about 5 days per year. Statutory accrual comes out to about just under 9 for full-time employees. The downside to the lump sum approach is you may front load all of the sick leave at the start of the year. The employee may be considering leaving the employer. They may be placed on a performance improvement plan. And instead of leaving, they may utilize their sick leave. It's, as I'm going to mention in a second, risky to ask for document support. So they might use all of their sick leave within the first few months of that year and then leave, in which case you'll be paying them for that sick time. SB 616 does not change the whether the employer is allowed to request medical support. So that has been a risky proposition. The labor commissioner's guidance suggests that employees cannot deny sick leave based off of lack of medical support. So unless there's some reasonable belief that the employee is abusing the sick leave, best practices not to require medical support to approve sick time off. And lastly, as with both the reproductive and bereavement leave, the employee handbook should certainly be updated to ensure compliance with the new sick leave requirements. Any questions as to either of those three leaves?
Ryan, I think we might hold questions just because we're running a little behind. We want to make sure we get through everyone. So we'll hold some questions till the end and happy to stick around. Yeah.
Sounds good. I'm trying to move fast, Holly.
Yeah.
California minimum wage. So it increased again this year to $16 per hour. The exemptions for overtime are about $65,000 a year. And once again, cities have their own minimum wage laws. And in California, thank you, almost every, the vast majority of cities have their own, the vast majority of major cities have their own minimum wage laws. So I live in San Bruno. It's one of the few cities in the peninsula that does not have a separate minimum wage law. Prior to 2024, there were no statewide industry-specific minimum wage laws. And in fact, across the country, it was pretty rare to have such industry-specific laws. I think we had Minnesota has an industry minimum wage for hotel workers, and New Jersey and Nevada have minimum wage laws for healthcare workers. But now, based off of AB 1228 and SB 525, we do have industry-specific minimum wage laws. So AB 1228 applies to national fast food chain employees. The minimum wage increases to $20 per hour effective April 1st. An $84,000 per year salary exemption for your exempt employees. And it applies to national fast food chains. So 60 or more limited service restaurants in the US with at least one in California with some sort of common branding. It excludes bakeries and restaurants located within grocery stores. This applies to over 500,000 workers. So that's approximately 3% of workers in California. And so the effects are that even if you're not in the fast food industry, your low wage earners may move to higher paying jobs elsewhere, which seems likely to put pressure on wages in other industries. The statute also establishes a council that can increase the minimum wage annually. Starting in 2025, so it's $20 per hour starting in April of this year, but that could go higher each year through 2029. And then there's SB 525, which applies to healthcare workers. And here we have a minimum wage that's going to increase to about $25 per hour over the course of the next few years. There are actually 5 different minimum wage schedules, depending on the size of the healthcare facility, as well as the nature of their payers. And healthcare workers are defined broadly here. So it includes virtually any healthcare facility. So it might be hospital, clinics, residential care facilities, or certain rehab centers, even at-home health workers in certain situations. And it applies to anyone working within the facility with very limited exceptions. So janitors, staff within the facility, people who perform laundry services. They don't have to be the people actually performing the healthcare services. And because of this, that's about 12% of the California workforce who's going to have a minimum wage of about $25 per hour over the next few years. There is an exemption process. The DIR is going to give more guidance as to how a healthcare facility may be able to get an exemption from the new minimum wage laws. They have to demonstrate that they are a going concern if they apply, but that's a very onerous process that requires the submission of significant financial documents.